I leave my spouse out of my will or trust? Or do I have to leave them anything? Or can I completely disinherit them if I want to? These are questions that, although not common, are questions that I sometimes get from clients. Hi, my name's Alec Oslin, and I'm an attorney at the Yanowitz law firm, where we've been assisting families with wills, trusts, and probate for over 30 years. Now, disinheriting a spouse. Again, not something that happens very commonly, but I do have clients who have those questions every once in a while. And my answer to those is yes, you can disinherit and not leave your spouse anything in your will or your trust. However, they may still have a right to get those assets if you completely disinherit them. Let me explain why. Minnesota law gives your surviving spouse something that is called an elective share. This is a legal right that allows your spouse to claim a portion of your estate, even if you completely leave them out of it entirely. So if you think you can just write them out of your will or your trust, well, yes, you can. However, upon your death, they can bring this elective share claim and still get some of your assets. Here's how it works. The elective share is based on the length of your marriage, and it applies to what we call an augmented estate, which includes more than just what's in your name. It can include joint property. It can make some gifts that you make prior to your death. And it can also include assets that are held in trust or in a business as well. In other words, you can't simply transfer everything out of your name and hope this avoids the elective share claim by a spouse. Now, the actual percentage your spouse is entitled to depends on how long you were married. It starts off at 3%, and it actually goes up to 50% once you've been married for 15 years or more. If you've been married a while, your spouse could have a legal right to half of your estate, even if your will says otherwise. There are a few exceptions. A spouse can waive the right to the elective share, but generally that is done through a prenuptial or postnuptial agreement. And for prenuptial and postnuptial agreements, they have to be done with full disclosure, and generally we need independent legal counsel on both sides of that agreement. So overall, in Minnesota, you cannot completely disinherit your spouse unless they agree to it in writing in advance. If you are in a second marriage, blended family, or just trying to make sure your estate plan reflects your wishes, this is something that you absolutely need to plan for. At Yanowitz Law Firm, we help clients create estate plans that follow the law and protect the people who they care most, without leaving surprises behind. With that, I'd like to thank you for watching today. Make sure you subscribe to our YouTube channel to find out when we post another video. Thanks. Have a great day. Bye.